So thank you everyone so much for being here. I'm really excited to have you. There is a lot going on in landlord tenant law these days, and especially, I don't know, around this thing called moratoriums. It has been an exciting time for this as we have slowly switched over from kind of the moratorium that we've known and loved in Oregon to not having it, but having different protections. And then all of a sudden the CDC came back and gave us some type of moratorium. So trying to splice all of those together has been entertaining. But I hope that this training will kind of help you. In the room, we probably have individuals who are tenants, we have individuals who are working with tenants, and people who are both. So just know that that's probably the audience here. We may have a few individuals who are property managers and owners. So being mindful about who's in the room, this is really geared towards those who are renters and those who are helping renters. So that's the audience here, but the information is useful for everyone. With that, let's jump into it. So myself, Caitlin Kennedy Young, and Angela Ray Huddleston worked really hard to put all of this together. Terry is also here doing his fabulous job behind the scenes too, so woot woot. And I just wanted to give you all an opportunity to get this information in a way that is most helpful for you. But I also want to remind you that none of us are lawyers. So anything that you hear here, we have worked really hard to make all of this legal jargon something that is really understandable. But if you've got some very specific situations, you'll want to contact legal aid. We can direct you to those places as well. But we ourselves are not lawyers, even though we've almost memorized landlord tenant law at this point. My goodness. Like I was saying, when we started this process with moratoriums, there were a bunch for us to track. And then things have changed. So right now we're really focused on the CDC moratorium, which is kind of what's happening in the moment, so federal. And then Oregon passed a couple bills this last legislative session, Senate Bill 282 and Senate Bill 278. And they all kind of weave into one another. I've seen some trainings where people try and do them one at a time and it gets rather confusing, and it was really confusing for me. So I gave up on that possibility, but I didn't give up entirely. So don't worry, this isn't the end of the training. Instead, I put them in a blender and I mixed them all up. So you'll get bits and pieces that work best so that you can kind of understand how they all join together. With that being said, we'll talk about the CDC moratorium. I think that's probably the thing that most people have heard right now. Yay, there's still a moratorium. The CDC came through. Yay. There's some caveats that we really need to know about on that. It's not the same as the Oregon. Oregon had much wider protections with their moratorium. So I really want to get that out there and get clear on that. There's a new grace period for any past due rent. There's also this thing that is called a 60-day safe zone. You might also hear of it as a 60-day safe harbor. It is the same thing. And that kind of goes with rental assistance for any rent payments that need to be made on a provider is paying for a tenant to get that. So we'll talk about what those payments look like, which is exactly where we start talking about payment funding that is available to tenants within Oregon. We'll briefly touch on the Landlord Compensation Fund. That was something that was previously instituted when we were looking at older versions of the Oregon moratorium. So I want to just cover a few things to follow up on that. I'm also going to share with you an absolute worst case timeline of events when it comes to if somebody does receive notices for eviction, how quickly that can happen right now. We'll talk about any leases that were set to end during the COVID moratorium time. And then we'll talk about some other protections that were also built into the law too, around eviction reporting, around credit, and guests or occupancy levels. And if that isn't enough for you and I just don't completely melt your mind by the end of this, I will have a slide which will be like 5 takeaways that if you hear entire presentation, focus on those for sure. So let's start off with the federal moratorium. After this, I'll have a time for questions too. So if any of the things that I've already just said that we're going over, you've got questions that you want answered, feel free to throw them in there. But as we talk through it, you can also put them in the chat too. So the federal moratorium is through the CDC. It is federal. It covers all of the US, which also includes Oregon, I know. The important part to this is it was extended. They just did this and it will go out until the end of July. However, this extension, it doesn't stop any evictions. It just kind of freezes them in their tracks. It doesn't prevent it, it postpones it. So that is an important takeaway. It's not preventing evictions, it's postponing them. When it comes to the federal protections, there are some really key things that tenants need to hit in order to qualify to even have the federal CDC moratorium protections. First, they have to at least have tried to get rental assistance. They have to be low income, which there are some pretty strict expectations when it comes to how much money they've filed in previous IRS or tax seasons. They have to have an inability to pay the full amount of rent because of lost job time, lost job in general, or hours being cut, or if there were substantial medical reasons. They have to have at least attempted to try and make partial payments when they could. And also, if they were evicted right now, the eviction would result in them either being doubled up or homeless, which would then increase the possible cause or increase the threat of COVID spreading. So that is why the CDC really got involved in this, because they were concerned that if people were losing their homes, it was likely that we would see rises in corona cases. So that's why. They have to fit all 5 of those. And not only does one household member, it is all household members over the age of 18 have to hit all 5 of these. There are additional things that I want to talk about too when it comes to the federal guideline. They have to sign a federal declaration form, which is not the same as Oregon's form. It is its own form. If they had ever signed that before in the past, which I imagine that most people have signed the Oregon one and not the federal, but if they had signed the federal one, then it still counts. They don't have to sign another one. They don't have to get that to their landlord. They're fine. A landlord cannot evict them if they think that they are a threat because maybe they've had COVID in the past and the landlord is like, I don't want anybody else in my building getting COVID. You need to leave. They can't do that as long as the person is taking care of themselves and their health and safety. If the person who has COVID has gone around and started just coughing on every doorknob, that is a different story and the landlord can move to evict then. But as long as they're being safe with their health and safety and of themselves and others, they can't get evicted. If an individual doesn't have access to print out the declaration themselves, but maybe they can find it on their phone and they can go to the link and they can see all of it. If they handwrite it and it hits all of the important parts that that federal declaration does and they sign it, that is the exact same as if they had printed off that official document and sent it to their landlord. So it is okay for them to do that. And it is also okay for them to do that in their own language. But remember, this is not the same as the Oregon declaration form. I'm going to say that a bunch of times. If you count how many times I say that during this presentation and you get it right, I will give you amazing glory and everlasting glory, right? You are a super winner. Like I said, People can do it in the language that they're most comfortable with. So whatever the household language is, they can choose to rewrite the declaration in that language or find one that's already available in their language, as long as it covers the same basis. And every adult household member has to submit documentation proving that they hit all 5 of those previous stated reasons why they are filing the CDC moratorium. But not all 5 of them have to give their copies to the landlord. One individual of that household can collect all of that and give it to the landlord at one time. It doesn't have to be every single adult. Important note here, though, is even if somebody does all of this and they don't have to pay July's rent when July's rent is due, they can still also get late fees for July. So know that. And I'll also talk about that it is not a for sure thing, right? Remember when I said it's prolonging and not necessarily preventing. So we'll go into depth about what that could possibly mean for folks. But once again, like I said, I don't know. It is not the same as the Oregon declaration form. If you need the actual declaration for the federal one, here's a link to it. You will get these slides, you will have it. I will also attach it in the email that I send you to so many times. But if a landlord still serves notice during July, there's some things that they need to take into account. So if the tenant hasn't signed that declaration form, or they don't qualify for it, they don't hit all 5 of those markers, and they haven't paid July's rent, then a landlord can serve the notice for non-payment. The notice of non-payments, though, have been extended. So before you were looking at things, most commonly everybody knew the 72-hour notice. That has now become a 10-day notice. There is also another notice out there in the world that's called 144-hour notice, which seems really complicated. Nobody's ever heard of it. It's just when a landlord goes, hey, you owe rent and you owe this late fee. So when they give you that notice, that is also extended out a 13-day notice. So they would end on the same time depending on what notice the landlord gives. Most often you'll just see the 72, which is now the 10-day notice. This is going to hold true all the way until the end of February next year. So these notices will remain at those prolonged timelines until next February. With the CDC notice, though, the landlord does not have to give a copy of the declaration form when they give the 10-day notice. That was not true with the Oregon form. With the Oregon form, they had to give it the same time they were giving the notice. This is not true with the CDC one. So tenants shouldn't be expecting it at that moment. And here's my big concern. So we'll start with worst case scenario and we'll start with best case scenario when it comes to tenants. Worst case, with the CDC moratorium, technically a landlord can still go through all of the processes to evict somebody. They can take them to court. They can have a first hearing. It's when they win that hearing and the sheriff would be scheduled to walk that tenant out of their household, that is the actual thing that it prolongs. So an individual may end up with an eviction on their record if they don't pay July's rent and just wait for this CDC moratorium. It's not great. What I've also heard, though, on potential best case scenarios is landlords are super confused about this, as we all are, and they are just opting just to not try and attempt to evict anyone in July. So those are kind of the two polar opposites, and I imagine somewhere we'll end up in the middle, but I wanted you to know what those might look like so that you can be prepared to see either of those. I tend to plan for worst case scenarios instead of best case scenarios, so plan accordingly to yourself and your own comfort. Whew, okay, that's me getting through the CDC moratorium. Let's go to questions at the moment. What has come up?
We have a question about the CDC moratorium extension. I know it was the original moratorium was expired in June 30th. Do you know when the CDC moratorium started?
So the CDC moratorium has been a continuously extension on extension. It started September 4th, 2022. And at that point, I feel like it was going to end at the end of October, and then they pushed it out to the end of December. And then a couple days before that, they're like, okay, March. And then from March, they pushed it out to June. And now what I'm hearing pretty loud and clear is that this will be the absolute last extension to the CDC moratorium. They are not planning to go another round of this. This is the end. So yeah.
Okay.
Good question.
And then we'll be sending links for both the CDC application and the OERAP. Okay. Does each household member over 18 need to write a separate hardship letter or use the form? Can you just clarify that a little bit more?
Yes. Every adult member over the age of 18 needs to complete their own declaration form and make sure that they hit all 5 of those markers.
Just for the CDC?
Just for the CDC, because there are no other moratoriums.
That's true. Okay, any other questions for moratorium stuff before we move on to the next more exciting jazzy stuff, I think?
There is one more question.
Oh yeah.
Will this recording be available later to share with coworkers?
Most definitely. Yep. I will hope to have it out by the end of today, but if not, I'll have it done through the weekend and you'll have it by Monday for sure, if not earlier. So anybody who registered for this training, all of these documents will go out to them too. But please don't leave us right now. Yes.
My first question is, I just wanted to clarify, when you were in one of the slides, it said something about not needing to do a new declaration. Does that mean that if I did my financial hardship declaration at the beginning of the year, that I don't need to worry about doing the CDC declaration?
As long as the declaration that you did then was the CDC declaration. Oregon had its own declaration, and that will not hold water for this one. So if you remember distinctly that you had done the CDC one before and didn't do an Oregon one, then you're covered. If you're like, oh, I think that was the Oregon one, double down and redo this one for the federal, just in case.
Okay.
Good question.
Might also ask if the moratorium that was in place until the 1st of this month, is that also was that also just postponing evictions, or was it preventing them? And I'm wondering how that has changed since then.
Perfect question. So what happened is we usually didn't really acknowledge the CDC moratorium because Oregon had much better protections for renters. So we always fell under the Oregon one, which that one wasn't necessarily postponing. It was withholding so that landlords couldn't go to court at all through this process. Like they could not start the court trials. They could not even send notices that would happen. It really prevented them from beginning at all, where the CDC one, worst case scenario, doesn't necessarily have that same protection. It just prevents from locking out, bare minimum.
Okay, that makes sense.
So we'll talk about the protections that Oregon has put in place next, where we don't necessarily, come July 1, yesterday, people need to pay July 1's rent. But there are additional resources available to make this easier. So we'll go into that right now, unless anybody else has any remaining questions.
Thank you, Anna. I did not relay your question as well. So I just really want to make sure that your question was answered thoroughly.
Thank you.
Okay, thanks.
All right.
There is one more question.
Oh, yes. Sneaky.
Does each household member over 18 need to write a separate hardship letter for or use form?
Yes. Yep. Most definitely they do. All right. Now let's talk about money. Past money that's owed specifically. And then we'll talk about rental assistance, which is funner money. So we get this grace period. There was a grace period previously. It kind of got dark there for a little bit and was unsure whether or not we were having one, and now it's back. So any rent during the COVID time, which for Oregon, we're specifically looking at April 1st, 2020, up until June 30th, 2021. That is what they call the COVID time. Any of that has a grace period of 6 months. It is due at the end of February 2022. This does not need additional declaration forms. Everybody in the state who's a renter has this right now. You are covered and protected under this. You still need to pay any back rent that is owed during that time, but you have 6 more months to get that done. You can do that slowly through the 6 months. You can wait and give it all on the 28th of February. I'm scared to say that that's a possibility. I would prefer slowly paying it so that you know. But you've got 6 additional months to try and get through that back rent. If you were making payments either during COVID times or if you are making payments in the future and trying to pay down some of that debt, here's how landlords should be putting those payments. First and foremost, current rent needs to be paid first. So if somebody pays $5 more in July than they usually would, all of July's rent gets covered. And then that $5 extra next goes into any utility charges that they owe the landlord for, and then any late rent. And then finally, if there were any other damages or fees or charges that were racked up during this time. Now, remember, those fees cannot be associated to late rent because they were not allowed to charge any late rent for the COVID time. But if you lost a key and you got a fee for that, or if you parked in somebody else's parking spot and there was a $50 fee for breaking the lease agreement in that way, those are the fees that could be adding up during this time. Okay, that's cool, but July rent, tell me more about when July rent is supposed to happen. Unfortunately, that's supposed to happen July 1st. So whatever is owed now for July is owed right now. Tenants who don't pay July's rent or any other charges that the landlord would generally charge you, a parking spot, utility charge, any of those regular monthly fees, you can get late fees on not paying those, and you can also possibly get eviction notices too. So those 10-day or 13-day notices of non-payment. But do not fear, we have a new Senate bill that was, what I'm hearing is possibly the fastest a Senate bill has ever made it through getting completely signed. It was a very quick process. Bill 278 is here. So let's talk about what protections that gives you. It is giving you a protection of what is called a 60-day safe zone or safe harbor, you might hear too. If an individual applies for rental assistance and they can provide documentation that they have applied, they don't necessarily have to have the funds from the rental assistance, just documentation that they've applied. They can hand that over to their landlord. Then the tenant cannot be evicted for non-payment of rent for up to 60 days from the date that they provided that documentation. Okay, big thing there. That rental assistance can come from rental assistance providers. And it needs to, when applying, those providers need to give a receipt that is dated for when that tenant applied for the rental assistance. And then the documentation that the tenant provides to the landlord, it can be in an email, it can be a screenshot of an email, it can be a written document, any other electronic document, any of those things. As long as it gets to the landlord. And then the goal of this is anybody who's applied for rental assistance shouldn't get an eviction while they're trying to wait to pay their rent. That is the true deep down goal of this bill. We wanted to protect people who are trying to do the right thing. And I know that I spent some time talking about a rental assistance provider. Who are those rental assistance providers? Rental assistance providers are anybody who would normally provide rental assistance. These could be nonprofits, they could be CDCs, they could be your local community action or your local housing authority. It could be your church that can supply that. However, if it is just mom who is giving you a loan, mom, family, and friends do not count. They are not regular rental assistance providers in the law or in the eyes of this bill. So it is really sweet that mom would write you a handwritten note. It is not going to qualify with a landlord. They're not going to give you an extra 60 days there. It is also important that that verification that is sent to the landlord is the verification from that third party provider, the rental assistance provider. If it's the tenant being like, hey, I applied on this date, trust me, please, smiley face, that's not going to work. It has to be from a different person saying, yep, this application has made it through. Any questions about that 60-day grace period?
Yes.
Okay.
Well, my question is, now in regards to this protection, is this also only protecting lockouts, or is it actually preventing any court processes from happening?
It's preventing the court processes from happening.
So as long as I complete my application goes through with the, it's the OERAP. Do you know what I'm talking about?
Yep, we got a slide for that in just a moment.
Okay.
Yes, as long as you can provide documentation that you've applied. You don't even have to provide the documentation that you've been approved. Just that you've applied, you get this 60 days. You have to provide that to the landlord.
And there will be a receipt that will be given to me.
Yes, yeah. I am hearing that some providers are a little slower than others trying to get those receipts out, but it is very well written into the law and the people who are providing this dollars that they need to provide that documentation as soon as possible. That being said, don't wait until the last minute hoping that you'll get that documentation to come through. So we'll talk about that in a moment as well.
Grace, I'm going to ask your second question first, and I'm just going to read it verbatim. So to be clear, this is only for July. So if a tenant applied for rental assistant funds for June or sooner, would we need to reapply for July, reapply for assistance for July to be protected from July as well?
I have a lot to say about that, but I also have another slide about that. So I'm going to put a pin in it.
Okay.
Angel's going to watch this like a hawk and promise that I answer the question. And if I don't, she's going to circle back to it.
Okay. And then our other question from Grace goes back to your slide about the order of how payments are applied.
Yeah.
If someone is getting rent paid by an agency, the same rules apply because it's just rent. Doesn't matter the source. Okay,
yeah,
cool.
Yeah. And so at that point, if you've got an agency who can like their funding is only specific for rent or past rent, whatever that is, then they still have to do it in that same order, but they couldn't pay for those utility charges, so they would skip over that. So it would be any current rent and then past rent, unless that agency specifically says that these funds can only be paid for past rent. So it would still be in that order, but it might be because of the funding, they might jump in at a different part of that order.
Okay. And yes, Jennifer, it does take time. As Caitlin will say a few more times, start applying for your rent assistance yesterday, and get your docs in order. So Jennifer just wanted to give a little shout out to that.
Perfect. Thank you. Okay. So I heard you say something about rental assistance, right? Tell me more. Good questions. I was hearing that in the chat, right? We want to talk about the money. That's the fun money part. So let's talk about it. There's this thing out there in the world, OERAP, right? Oregon Emergency Rental Assistance Programming. Some of you who are providers have probably heard a lot about this. You might have heard about CARES money. Like, there is money coming in to try and help people. This is a statewide funding program. It's working with a lot of different providers to try and get this money out of the door as soon as possible. The funds come from a federal program. There's about $500 million going specifically to Oregon to pay for the emergency rental assistance. That funding won't go anywhere else. It pays for emergency rental assistance. Who is eligible for this are low-income households who have past due rent, utilities, or other housing-related expenses. It can also pay for up to 3 months of future rent. So even if somebody is applying because they owe past rent, there may be a possibility that they also get past rent paid for and future rent too. And these payments, even though the tenant can apply directly with the state, they would go directly to the landlord or the utility provider. Remember, this can apply for utility assistance as well. And you can do a mixture too. It's not just like a landlord or utility company. Somebody can apply for both of those. It is important to know that not all applicants will get the funding. The state is really trying to prioritize those that have been hardest hit by COVID, by wildfires, and the most vulnerable populations first. That being said, they're not just going to take everybody's application and wait until February to be like, oh yeah, here's the top tier of the most vulnerable. It's going to be an on-rolling basis. They're not going to wait any of this out. So apply, apply, apply. Tenants will have to gather some documents to showcase that they are eligible. This would really be around low income. That is going to be one of those highly important moments of you showcasing eligibility requirements. Tenants can apply directly on the state website for this. You can also go to providers in your area as well, and they can help people through the application process. And then tenants should be checking back often on the website to see if their status has changed. Do not wait until the last minute to file these applications. So technically, you really have up until your first court appearance to get this documentation in. Do not wait until 5 minutes before you're supposed to be in court to think you can easily do this on your phone and go, hey, look, judge, it's fine. You can forget any of this ever happened. It's not going to be that quick of a turnaround. So start applying now. You remember the 60 days starts when you hand over that documentation to the landlord. So even if you get documentation tomorrow, if you haven't gotten any notices from your landlord, you don't have to hand that out. If you are able to pay July rent right now and you're waiting on this assistance for back rent, or you're nervous about August rent, you don't have to give over that notice just yet.
Is this the last slide for our OERAP?
I'm going to talk about the Landlord Compensation Fund too, and then we'll have questions after that.
Thanks.
Okay. Does it make more sense right now, though? Do you feel?
Yeah, actually,
okay.
Thank you. There's two things I forgot to make sure we had in this presentation, Caitlin. Yeah. One of which is some folks may need access to computers in order to fill this application out. In Multnomah County, there's like 8 libraries that are open for full services right now. I'll put that link in the chat. But if you're not in Multnomah County, that is something to think about, maybe trying to access, get computer access for your folks. I know our agency Transition Projects is now able to meet in person sometimes. So that may be something you can do to partner with some agencies to help. And secondly, immigration status has no effect on applying, either at the time of application or in, how do you say, like future
Receiving funds.
Yes, thank you.
Mm-hmm.
And I think that's really, really important to note, especially for our most vulnerable populations.
Yeah, yeah. And I'm seeing some good resources in the chat as well about other places. And I highly recommend 211 is going to be a great resource too, to figure out where you can go in your area to try and get this printed or submitted. So,
Caitlin, can I just ask you to repeat the 60-day, when the 60 days starts?
yes.
Thank
So
you.
the 60 days starts the moment that the tenant provides documentation that they have applied to the landlord. It is not necessarily the moment that they get that documentation. It is the moment they have handed it over to the landlord.
Thank you.
Mm-hmm. Good question. Were there any other things, Angela, that you felt like were important on this slide before we go to the next? Okay. All right. So a while ago, we had this thing called the Landlord Compensation Fund. Where in the world has that gone, right? Well, the Landlord Compensation Fund did come out of a previous moratorium bill. That one was in December, and it was House Bill 4401, just in case you also were a nerd about House Bills numbers, but that's fine. It is different funding than the OERAP funding, so just be mindful of that. It came from different pot of money. It was state money that was arbitrated to go towards this. This type of funding for the Landlord Compensation Fund did end. It was scheduled to end. It had to end due to where the funding was coming from. It ended at the end of June. The payments at that point were for landlords. It was up to 80% of what a tenant owed them. And then the landlords had to forgive the other 20%. They couldn't go after the tenant for the other 20%. They had to forgive it. So some landlords still might be receiving some of these funds. No more landlords can apply on behalf of their tenants, but some of them might still be in the process of getting the funding. So be mindful of that. But now, because of the bills that were passed, they're going back and they're giving 100% of what was owed to those landlords back to them, so that 20% forgiven is now going to be paid by the state again to make them whole. So they'll get 100% of what is owed to them. If they already got 80%, they'll get a secondary check for the 20%. Anybody who hasn't been paid yet will just get the 100% instead of two different payments. Tenants will receive documentation that this has been paid on their behalf, so keep that for their files. And it's also really important that if tenants know that their landlord ever got paid out through this Landlord Compensation Fund, they should be telling whoever they're applying for rental assistance with. Because just because the funds don't come from the same places, it doesn't mean that those who are overseeing the funds aren't the same place. So funding can go a lot quicker if a landlord has already been in the system because of the Landlord Guarantee Fund. So if somebody is applying for OERAP funds, then that is a possibility that this can move a lot quicker for them if they've already gotten this. Oh, okay. Before I go back to questions. I did want to do a worst case scenario, unless there's anything. Angela, do you feel like I'm missing anything between the two slides?
I think we have a few questions. It would be pertinent to go to
Okay.
the calendar's really good. I think everyone's really going to like it.
Okay.
So I just want to maybe tie a few things up before we go there.
Perfect.
So Alexandra asks, what if it takes a while for the landlord to get the payment? It will take some time.
It will.
I don't know if there is an actual time frame yet, Caitlin, that you could speak to on that, but
so the time frame there, we don't necessarily know how long it's taking for people to get those payments. I think it's gonna depend on how many people apply, and if anybody has been listening to me, I've been just screaming apply. So a lot of people are gonna apply really quickly, and it's gonna bog down the system. But I think it's more important that you get that documentation, because then you can provide it whenever you need to. Unfortunately, it's a 60-day window. Landlords are expecting a payment within those 60 days. And if they don't receive the payment in 60 days, they can move forward with a possible eviction notice. So being really careful about that and always constantly following up too. But all of these agencies are geared up, ready to try and get this funding out the door as soon as possible. It's a hot potato situation, and they don't want to be holding the funds any longer than they need to.
We were also asked if there's a form that the landlord signs or dates, like when they get the receipts, and there isn't.
There's no form.
Simply just for the landlord to know that you've done your diligence. Here's your receipt.
Yep. I highly recommend, though, that you put it in a form that you can showcase for sure that it got sent to them. So even if they come back and say, I never saw that, if you can provide the text message where you took the photo of it and it went to them, that is some documents that
it's a receipt.
It goes to court, you can show that. Yeah. Email form as well. I highly recommend having any kind of form where you get some type of receipt. Maybe your landlord will write you a receipt when they receive it, just so that everybody's on board, but they don't have to do that. Yeah. So be mindful of it.
I'm a fan of covering your bases. So, and then Addison has a question, and I'm going to read it because this is where the vocabulary gets a little funky, because there's a grace period and there's the safe harbor. And so it says, how long are tenants able to apply for this grace period? Is there a specified timeline or just till money runs out? So I'm assuming she's talking about the rent is due July 1.
The safe zone, safe harbor.
Yeah.
Grace period, think about that as any money that is previously owed during COVID times. Grace period. Anything that is owed in the future and you need a kind of stop moment to try and figure that out, that is your safe harbor, safe zone. So it's going to get confusing. It just always is. So I'll keep trying to pull those pieces apart, but no worries there.
And there isn't a time. Okay, she says that helps, but there isn't a timeline. People can apply.
Yes. Until. Then I'll have a slide for that too.
Okay. ...
One day I'm going to be really good at PowerPoint, and I'm going to have like sneaky little buttons and be like, oh, they're asking this question, and then like hit a little doodad in the corner and it will just magically go to that page. But
maybe I set you up a little for that. Maybe I tried to be your butt.
So first, like I said, I like to go through worst case scenarios. So we're going to go through the calendar of events of a worst case scenario. If a tenant does nothing, there are no payments, July edition. So this is our current calendar. I'm going to show you how quickly an individual might be asked to leave their home if nothing happens. Yesterday, my rent was due. I didn't pay my rent though. I got nervous. I didn't quite have it yet. I don't know what's going on. Maybe there's an eviction moratorium. I'm trying to figure things out. So I don't pay. Well, on the 4th, at the end of the 4th day, 11:59 p.m. by state law, if I have not submitted my rent for that month, now I owe a late fee and the rent. So it has come, midnight has struck, and I now owe rent and a late fee. This is where you might see that 13-day notice, but it's just you owe rent and a late fee. Well, I ignore that. And now it's come time where it's the 8th day of the month. I have not seen rent. The landlord has not seen rent. The landlord hasn't seen a late fee. I haven't talked to them in any way whatsoever. They can hand me what is now a 10-day notice to pay or leave, right? If I don't pay by the end of those 10 days, they can file an eviction notice. So this would be the first filing with the court. So far, it's just between me and the landlord. No court is involved. It's not necessarily on my record as anything other than maybe a bad landlord reference at that moment. Well, it comes the 18th. I have still not communicated. I haven't paid anything. Technically on the 18th, when that runs out, the landlord can go immediately to the court. Don't pass go, don't collect $200, just straight to the court, file documents. However, for this month, that ends up on a Sunday, so courts aren't open on Sundays. The earliest that any landlord can file this would be on the 19th. So Monday the 19th, the landlord goes to the courts, files the notice with the courts. This is now when it officially shows up as an eviction on my record. The court is now involved. It may not be a full-fledged eviction at the moment, but it is the start of this process. On the next day, I received notice from the landlord that I have a court hearing. This will tell me the date that I need to go to the courthouse. It's important when somebody gets this type of notice that they go to the courthouse. This is not the time to flee and not go to the courthouse. If they do, then the landlord goes, the tenant doesn't show up, it ends up in the landlord's favor, and then there's an eviction for sure on that person's notice. Background. Usually, once you get that court date summons, the earliest that this happens is about a week away. So we may start seeing court dates start happening on the 27th. That is going to be the earliest that we start seeing court dates happen across Oregon. Each court system is different depending on their county of how quickly they can hold trials. The shortest one I do believe is in the Eugene area, and it can be a 2-day turnaround. So I might go to court for the first time and go, hey, I don't really trust this. I want a trial. They're going to give me a trial pretty immediately in the worst case scenario. And if I lose on the 29th at trial, I don't have anything together, then there's a sheriff's lockout. It's a minimum of 4 days that I am given between losing at the court to being locked out. So absolute worst case scenario, there's no, it's as short as it possibly can be. This is what it's going to look like for some of our tenants who don't apply for rental assistance, who don't pay for July rent, don't find some resources for it. That being said, this kind of golden time of the 10 days, I feel a little icky saying this because to set our tenants up for the best success and the most amount of time between when they get a notice to having a freeze to possibly paying rent, it would be ideal for a tenant to wait until they receive a 10-day notice before they supply the landlord with the rental assistance. Because once they give that rental assistance, like I applied for the rental assistance, then that starts the 60-day countdown window. This could potentially give them up to 18 days plus 60 days. That being said, I get really nervous because if people get down to the wire and they're trying to do it like the last 3 minutes and they forget or they get there late, like it can move to the court systems. And I don't want that for people. So ideally have them apply at some point in that 10-day window, but if it's earlier, it's earlier. So a follow up, the 60-day safe zone that we're talking about, so that I've applied for rental assistance here is I'm showing you that I've done this. That can happen all the way up until February 28th, 2022. So just because I'm terrible at graphics and you've seen this graphic already, I wanted to remind you that we are here at the very beginning of these 8 months. So, ta-da. One day, better graphics department, promise. This 60-day safe harbor will end at the end of February. After that, it doesn't matter if an individual gives over this rental assistance declaration, it's just not going to count anymore. Tenants should apply as soon as possible for the rental assistance. You can apply several different places, double down, triple down, go anywhere, to your church, to the state, to your local CDC, wherever you want. Apply, apply, apply. And just because one place gave you a 60-day notice doesn't necessarily, like if your church gave you that notice that you've applied for rental assistance, so then you've got like your secret get out of jail free 60-day window card. If the church falls through because they've already paid everybody else's rent and they don't have your dollars, if another one of those options came through and you can get funding from them, you don't have to have a different letter. Like that 60 days still qualifies regardless of wherever that funding comes from. And the tenant should maximize the amount of time for that safe zone. So if they do want to add those 18 days before they can actually start the eviction notice, they can, but I just would be really concerned about that. So be quote careful with that. All right, that was a lot of information. Tell me what questions that we have right now.
I'm going to start with the most relevant because you just talked about, you know, spreading out your applications, really getting out there. So is there any way that like providers are tracking this? Like, can I double dip? Can I get money from transition projects and Bethel Church?
So all the funding is coming from the same source. It just might be from the different providers. So the providers on their end, they may not know that you've already doubled down. So the secondary person might approve, but when they actually go to write the checks, it's going to be Oregon Housing and Community Services, and Oregon Housing and Community Services is going to check their records and go, hey, this person's already here. So apply every place, but know that you might hit those snags. There's going to be a lot of people applying. We don't know how often they'll catch those or not, but I'm just saying that all the funding comes from the same place. So yeah, they do have the ability to double check if somebody's already received it.
Okay. So we have a question about the 60-day safe harbor. If I applied and showed my landlord my receipt before July 1, right? So I think, well, I'll let you ponder that. If someone gave their landlord the receipt on 6/11, is that when the 60-day safe harbor started?
Let's keep that in the chat. Because I have mixed feelings about this and I want to double check and I want to read the bill. Before I get that. So I'm hopeful for you, but I'm not 100% and I don't want to share anything too soon. So I will put that when we send out all the slides and the recordings, you'll get an answer to that as well.
Okay. As far as our new favorite date, February 28th, 2022, if I don't apply for rental assistance until February 27th, do I get 60 days from that? Or is the 28th when is the last day of this 60th day?
My understanding of the bill, and this one I feel confident enough to say out loud, I will double check it though, is that as long as you have applied and you can show that receipt and it was given to you before February 28th, 2022, you're golden for another 60 days. It's not necessarily that the 60 days has to happen in there, or in that case, they would have just said that this would go until December and then that would have been this plus the 60 days. So yeah, no.
Okay, good job. I thought that too. And we have a longer one that is I think it's more of just like it's a lot happening.
Okay.
So just because you've applied for, we've already kind of touched on this, but just because you've applied for the rental assistance doesn't mean that your landlord is going to get that payment within those 60 days.
Right.
You know, the question is, do we think the courts are going to be okay with us starting an eviction process? And, you know, I think there's a gray area still because we haven't had to test that quite yet.
Yeah, we definitely haven't had to test that. I think that we're in a situation where I think the courts want to be supportive and they'll be swamped, right?
Yeah.
So the least amount that they have to put on their plates, which is I'm just going to extend this and we'll see what happens, is probably best for them. However, we have a lot of landlords, big and small, who have not received rent for a really long time. And there are business implications, there are livelihood implications, there are life implications. So all of those feelings are gonna come into play in those as well.
Mhm.
So I can't quite say. And sometimes we see courts kind of figure out as a group what they're going to do, and sometimes we see judges figure out what they're going to do individually. So yeah.
I think though it's important to note, to add on to that, that the landlord is getting these funds directly. It is not, there's no in between.
I've seen Jennifer's hand up.
Oh
for a
gosh,
couple
I'm
times.
so sorry. Sorry, Jennifer.
Oh, lowered. Okay, never mind. One other person was about to ask a question.
I was.
Yes. Yeah.
I have a few actually.
Okay.
I'm wondering, as far as this was from one of the previous slides about the OERAP.
I'll go.
And I am wondering if I understand correctly, I can apply for that for this month's rent.
You can apply for this month's rent. Yeah.
Okay.
Sorry.
So that will
all the way back.
Sufficient in making me safe for this month. If I
yes. Yeah. Yeah. So the idea is, if somebody wants to wait until they get that 10-day notice from their landlord, if the landlord is going to supply them with a 10-day notice this month, that would be the ideal time to give it over to the landlord, just to have more time, just in case. But yeah, you are protected as of this month. It can pay for past rent, it can pay for current or future rent too. So any of those are covered under it. Good question.
What happens if, like, for example, I'm able to somehow manage to find the funds to pay my rent, the remainder of my rent for this month, but I also want to apply for this and to be protected as much as possible? Can I do that and still apply, or would that implicate or make the process of application harder?
No, I would say still apply, because remember, it can pay for future rent too. Maybe you are golden for July. You have saved up all your money. You've got July in the bank. August seems a little bit more unclear, right? So apply now for August. Like, if you could apply yesterday, right? Like, anytime that you apply right now is more important, because it may take individuals longer than those 60 days to get stuff. So if you start that process, the sooner the better. And possibly you're good on July and you're good on August, but you need to pay back time, like COVID rent, right? What was due prior to. And so you're applying for that, but by the time they get back to you, you're now looking at September rent and you're unsure. So you can be asking for that back rent and September's rent too. So apply.
I think it's also important to note, Anna, that just because you're applying for rent or rent assistance, it's not starting the 60-day time clock. That 60 days doesn't start until you show the receipt.
Okay. So this is really hard for me to verbalize this question, but I'm wondering, basically, I have no income right now, and the money that I have is just for me to survive. And I want to make sure that do everything I can to stay in my place, but I don't want to jeopardize my livelihood right now.
Right.
I'm wondering if, for example, I apply and give them the documentation and I do not get the funding, I'm not approved. Am I then able to, if I get that within the 60 days, they tell me no, am I able to, like if I'm able to secure the funds for the past due rent for, am I able to pay that? Or are they already able to take me to court and be like, you didn't do this, the funding didn't come through and you're causing problems financially. So could they,
Well, yeah, that's a good one. So I'm going to think through this and we can look into a more detailed answer. The 60 days happens because you have receipt that you went to an actual third party rental assistance provider and applied. That gives you the 60-day pause. It might mean that in between, your mom comes through and pays a part of your rent, right? Or whoever, a loved one who is not necessarily a rental service provider. I think your landlord is going to be excited to have that funds regardless. And I mean that gives you more time to maybe then the state comes back and is able to provide rental assistance. So I don't what that documentation provides is that extra 60 days. It doesn't necessarily mandate that the funding has to be from that provider,
okay,
right? Because you can even get denied from the original one that you showed, but then you went to your church and you got funding from there and you can still pay with that funding. So
and as far as I understand, the ORAP will for sure give me an answer within 60 days of applying.
I am hopeful.
Okay, but that's the,
That is what everybody's plan is at this point. They know that this is going to just be a tidal flood, but everybody's prepared for that much excessive amount of work to get this done. And everybody wants to see people stably housed. So those agencies are going to do absolutely the most that they can and know that they've got that time crunch for every single person.
okay. One last question.
Mhm,
This was on the slide that had to do with the timeline.
mhm.
And I'm a little bit confused because I have, from
That's
what
good.
I've learned in the past, I was told, if I remember correctly, that when you go to court,
Mhm.
um, and the judge rules something, to evict you, that they give you 30 days. So I'm just confused about the sheriff's lockout,
Yeah.
because isn't that supposed to happen when they rule and they give you 30 days to move if it's for non-payment?
They don't have to give you the 30 days.
Has that always been the case?
Yeah, they can. They can give you extra time to move out. The minimum is it has to be at least 4 days between when the landlord has officially legally taken possession of the unit, like in paperwork, to when the sheriff would ask the tenant to leave. That could be a longer time. Maybe the landlord's like, I would rather give this person a month to get their stuff out than trying to clean it and do all of this additional work. But at bare minimum, it's at least a 4-day process there.
And we don't know what the 30 days is in regards to.
There are several different notices out there in the world. We're specifically talking about non-payment of rent here, which comes with its own timelines, but there can be 30-day notices. One of the most common ones is if the tenant is giving their 30-day notice, that's a 30-day that the tenant is going, I'm willing to leave. And those are things too that at the first appearance or possibly at court can be negotiated into the final statement there. But like I said, this is the absolute worst case scenario. If nothing goes in the tenant's favor, this is how quickly it can move in July.
When it comes to the trial,
Mhm.
or the first court appearance, could you tell me a little bit about how that would work in terms of what would happen and if I can request a trial or so
Mhm.
that I know what to expect if that happens?
Yeah, yeah. So you are most welcome to always request a trial. I think anybody who is requesting a trial, asking for some type of representation or trying to get some representation there is helpful. There are 5 reasons in which one could be successful at arguing in trial too. And most of the time it has to do with the notice itself was not legal. The time frame that was given was not the correct amount of time frame. The way that it was served to an individual isn't the legal way through the process as well, or the time frame given on the serving wasn't the legal way, or if this feels like it's been retaliation or discrimination against the tenant. And that is a whole bunch of information that is not necessarily in this slides, but I will, Angela, can you write those down and we can send those to in the Q&As that follow up. So anybody who had questions about that, if I moved too quickly through those answers.
So those things that you just listed are discussed on the first court appearance or in the trial, if there is one that is happening?
Usually at the first court appearance, if an individual is lucky, most of the time the judges would really prefer that the tenant and the landlord or whoever may be there for the tenant or landlord go and figure out a solution before coming into that first appearance. Go try and figure out what you're going to pay, when you're going to pay it, how you're going to pay it, or when you're going to leave, how you're going to leave, all of that. Come to the judge, tell us that, we'll put it in an actual document. If that doesn't work out, if that mediation, self-mediation doesn't work out, then either party can go, this is not working. I need a trial to resolve this. And then that's usually when that's scheduled. And then the trial is those 5 things that a tenant can argue.
Okay.
Yep.
We also have a hand up from Tatiana.
Yes, thank you. I have a question. So correct me if I'm wrong. The 60-day rule applies to the current rent. It's kind of prevent from eviction if I don't pay, let's say, July or August rent. Am I correct?
Yep, all the way up until February of next year rent.
Okay.
So that 60 days really gives that window, because any back due rent, right, that COVID related rent has those 6 months to pay out. So that doesn't need to be paid until the end of February. So there's no need to have an additional 60-day window for those, because it's already a 6-month window guaranteed.
Okay. And I guess that was my question. Like, if let's say we are in February of 2022, can I use that 60-day for the past due rent? Let's say if I did not get funds up until February and I need additional a couple of months or something.
Unfortunately, it's not gonna go for that. So, well, okay. The rental assistance can actually pay for back due rent, right? But I'm curious. I'm not sure that it would give, well, we're going to put that in the chat and we're going to figure it out detail. I'm about 50-50. I'm 50-50.
Okay. Thank you.
No,
Thank
that's
you.
a good one. Thank
my
you.
question would be like, if I'm current and if I'm, you know, paid all of my current rent from July until February, but that past due, you know, if I'm still applying for it. So.
Right. Yeah, I can see arguments for and I can see arguments against. So I'm going to reread the bills and I'm going to get that clear language for you. Angela, can you remember that one too? Thank you. Okay, we've only got a few more slides too. Trust me, we've gotten through the bulk of it. Thank you all for hanging in there with us. So let me speed through those. I wanted to also note for folks that if somebody's lease was set to end during the COVID moratorium, so last April 1st, 2020, up until June 30th, 2021, if they were in a lease agreement that was coming to the end, it had been almost a year-long lease, we're not interested in renewing, they couldn't be evicted during that time because they didn't want anybody to just be out and homeless. So their leases just kind of froze in midair, just went through a time warp and is stuck right there. However, that doesn't necessarily mean that they've entered into new lease agreements with the landlord. What it means is it is frozen in place, but they have to leave by August 31st, 2021. That it's not an extension. It doesn't provide any additional relocation assistance. This is a way to say, we wanted to keep you safe during this time, but our plan is still for you to move forward and find another place to live. So anybody, regardless of when during that time frame their current term was up when it came to lease agreements, they have until the end of this August to leave their apartment. In these situations, landlords can deduct any past owed rent from the deposit. So just know that if anybody is in that situation, that is fine for them to do. Other protections that these laws carved out are, there are protections around eviction records. We understand that people have had to experience quite a bit through this, and maybe they've gotten some landlords who have been really frustrated with them or just not super great. And individuals were evicted for minor violations because maybe the landlord would have preferred to do a no cause or a termination because of non-payment, but they couldn't use those. So then they were finding these weird, tiny little loopholes to evict people for. We know that those evictions can stain somebody's record for a really long time and jeopardize their housing stability for years on end. So landlords are prohibited from considering any evictions, any of them. Non-payment were not allowed, non-cause, no cause were not allowed. But if somebody got a lease violation because they had constant noise complaints, right? That still cannot be considered if it was given to them during the COVID time. So April 1st, 2020, all the way up until August 28th, 2022. So this even covers that grace period protection. Any evictions that happen during this time, landlords cannot consider, future landlords can't consider. If somebody did receive an eviction during this time and there are no fees attached to it, or somebody has already paid off any of those fees, they can get and kind of express expungement. So they can have those records sealed. It still does cost, it's the cost of a filing fee, which is usually around $80, but they can have those records sealed. So any future landlords cannot see those evictions, regardless whether it was a tenant-based reason to evict or not. That is super awesome. Yay. Other really cool, awesome things too of this is credit protections. We also know that some people, their credit was severely damaged through COVID. And that can be a huge barrier for them getting into housing in the future as well. So protections were built in for this. Landlords cannot report any of the rent debt, or if there were late fees or damages, any of that debt that was owed to them, they cannot report to credit bureaus between last April all the way up until this last June, the end of June. Any debts that were owed to landlords can't go to credit bureaus. They also can't tell future landlords about any of those debts. Nope. But they can still tell credit or screening companies. So that's a little worrisome. But to double down in this and do a double but, potential landlords cannot take into consideration any of those past non-payment of rents or rent debt or rent-related debt that happened between April 1st to all the way up until this coming end of February. They cannot take it into consideration at all until January 2nd, 2028. Yes, I said 2028. A long time in the future, they cannot take into any consideration those credit. The other thing that came out of this too is there's protections for guests. So some individuals are having to double up. They've lost their homes, fire, COVID, any of those things. They've had to double up, and they're worried about retaliation from landlords saying, you've got too many people in your home. That can't be the case. Landlords cannot set stricter guidance on occupancy levels than what local laws or safety regulations consider. So as long as the fire department, let's say, if they've got some maximum capacity expectations around a home or a rental unit, that is the standard that the landlord needs to be at. And they can't be like, I know that this is like a 5,000 square foot room, but you only get one person in it. No. Up until March 1st, 2022, landlords cannot charge any late fee or charge any fees or terminate tenancies based on other guests staying with them. So people can't get fines for having people there. If a guest is going to stay longer than 15 days in any given 12-month period, the landlords are required to go, you've been here a bit, I'm going to screen you. But they can only screen for safety related things. Hey, how is this person at their past rental? Did they burn down the place? Hey, how is their criminal history? Are they a safe person to be around my complex? Anything around credit or income, that person is not paying rent, so therefore they shouldn't be looking at those pieces. They should just be asking if this person is safe enough to live there. If it is that they are safe enough to live there, that's fine. The landlord can also ask them to sign an agreement saying, hey, I'm going to follow everything that is stated in the lease agreement. I know that I need to keep my noise levels down. I know that I'm not allowed to have pets, blah, blah, blah. Whatever is in the regular lease agreement, they're asked to follow those ordinances, and a landlord can have them sign that. But they are also understanding that they don't have the same rights as the actual tenant because they're not paying any rent. They're just an additional household member at that point. So those were the additional kind of catch-all protections at the very end that were lumped into here. But most importantly, what if the landlord just doesn't follow any of this law? They don't know about it. They don't care to know about it, whatever it is. They don't want to follow it. Well, then they're liable for up to 3 months of rent plus actual damages. Somebody can actually take them to court and get this back from them. That is any part of this, even if they aren't, if you are applying for a place and they look at your credit during this last time and go, whoa, that's trash, I'm not renting to you. Doesn't matter, even if they're not your actual landlord, they did not follow this law, you can take them to court for this. So, whew, that is a lot. And I can imagine that it's a little mind numbing because it has been overwhelming to a lot of us. But I'm going to ask, is there any pressing questions before I just tell you, if you have listened to nothing else that I've told you, I've got a slide with like 6 different bullet points as takeaways.
I think I just have one question I missed from the chat earlier, I think. Can a tenant utilize the 60-day safe zone more than once during the time it's available if they need rental assistance more than once between now and February 2022?
I feel like this came up in the meeting that we were in yesterday, and I think I was just heading into that meeting. Angela, do you have a better answer for me?
Sort of.
Okay.
So the 60-day starts when you show your documentation, and you really only get to show that documentation once.
Yeah.
So if you need, and that's where the OERAP is great because it can give you up to 3 months of future rent assistance. So that may be something that you would want to know at the time of application, but it's kind of a one and done. Once you, that's it.
I also have a question.
Yeah.
This is regarding when you were talking about the credit being reported as of the 1st of this month.
Yeah.
You know, how, is that automatically going to happen, or is there a chance of that being reported? And when does that happen? Does that happen on after the 4th?
So if somebody owes for non-payment of rent, right? That's what you're asking, if a landlord can go forward and try and get it to a credit bureau. This is tricky. So most of the time, landlords aren't usually working with credit bureaus until somebody just hasn't paid them for a very long time and they have moved out, and the landlord would rather just get paid by a third party collector and let that debt be free in the world, than if a tenant is still living there at that moment. But there are some places where people can have their monthly rent go onto their credit score and hopefully usually do positive things for their credit score. So it really depends what app or what way the landlord is choosing to take those funds.
But it would be probably safe to assume that if it's never affected me and I'm still living there, that I'm good for now.
Yes. Yep. Yeah.
So, I'm sorry, go ahead.
Yeah, a landlord during this entire time, this has been since the eviction moratorium in Oregon started last August or last April. This has been in place and it will continue to be in place for individuals. So they've been really careful on those credit protections and wanting to make sure that people are secure in that. So during this entire time, no landlord should have been reporting this ever. And if they did, 3 months worth of rent could be yours. So,
okay. I have one other question. I'm hoping you could answer this.
Yeah.
I've asked other people about this before, but I just keep coming back to it. I pay my landlord. I send him my, I either send him or have another party send my rent to him. He lives in another state. And I know that since my rent is due on the 1st, it has to be like processed and stamped by the 1st. But I'm wondering in regards to the being like officially late on the 4th, does that mean that if it's processed and stamped by the 4th, that it is like on time, like within that period, even if it's sent by mail?
Yep.
Okay. Thank you for that clarity.
Yeah. Perfect. Okay. So I'm going to go forward, and if there's nothing else, I'm going to hit those key bullets, and then you are welcome to drop off, or you can stay on and ask a billion more questions. I am happy with either. So the key takeaways, if you have just decided not to listen to me at all during this time, that is fine. There's a lot. You'll get the recording of this. 1, solely don't rely on the federal moratorium. Great if you want to file it, but don't believe that that's the catch-all be-all. If you are going to file it, make sure that you file the right documentation. It's not the Oregon, it's the federal. So make sure you get that declaration in and know that it's the correct one. Money that is owed to the landlord between last April all the way up until the end of this June, so earlier this week, is now owed by the end of February, beginning of March 2022. July rent is due now. Apply for rental assistance like yesterday, like from a bunch of places. Apply. Hold off giving that rental assistance application confirmation to the landlord until you get the 10-day notice, but before the 10-day notice ends. If you want the maximum amount of time, that's the time that you should get. And then applying for rentals in the future, you should know your rights around that credit and eviction history screenings too, so that you've got some protections, and apply and communicate. Here is that information again. It was on an earlier slide. It's back here now. Yeah. Last, we've got questions. That is kind of the end of our slide. Thank you so much for being